Welcome to my video. Today, we're going to discuss an important topic that many people get confused about. Does the law allow any use of a copyrighted work without permission of the owner? Stick around to find out what's legal, what's not, and how you can stay safe while using someone else's work. Does the law allow any use of a work without permission of the owner of the copyright? And if so, which are they? Yes, the law does allow certain uses of a copyrighted work without the permission of the copyright holder. These uses are permitted under the doctrine of fair use or fair dealing, which allows the use of copyrighted material for limited purposes, provided the use does not harm the market value or the commercial interests of the copyright owner. In India, these exceptions are prescribed under Section 52 of the Copyright Act, 1957, which provides a list of specific situations where copyrighted works can be used without permission. The primary exemptions include 1. Use for research or private study. Copyrighted works can be used for research or private study, provided the use is non-commercial and the work is not reproduced in a way that undermines the author's rights. Example: a student may photocopy a chapter from a book for the purpose of studying at home, as long as the copy is not distributed or sold. 2. Criticism, review, or news reporting. Use of copyrighted works is permitted for criticism, review, or news reporting, provided the work used is not altered and the use is fair. This allows for quoting or referencing copyrighted material in a critical or analytical manner. Example: a book reviewer can quote excerpts from a novel to provide critique, or a news outlet can broadcast a segment of a film for reporting purposes. 3. Use for reporting current events. Copyrighted material may be used to report current events. This exemption applies specifically to the press and media. For instance, news broadcasters can air clips from television shows, films, or other works as part of their coverage of breaking news. Example: a television station can use short clips from a movie in their coverage of the film's release without needing explicit permission. 4. Use in judicial or legislative proceedings. Copyrighted works can be used in judicial proceedings, such as court cases, or in legislative or administrative procedures. This exemption ensures that copyrighted works can be cited or used as evidence in legal matters without needing permission. Example: a court may use excerpts from a copyrighted book or film as part of a legal argument or during a trial. 5. Performance by an amateur club or society. The performance of a copyrighted work by an amateur club or society is allowed, provided the performance is for a non-paying audience. This means that amateur performances, such as school plays or local theatre productions, may include copyrighted works without needing a license, as long as there is no financial profit involved. Example: a community theatre group can perform a play for free to an audience without paying royalties to the playwright. 6. Making sound recordings of literary, dramatic, or musical works. Under certain conditions, sound recordings of literary, dramatic, or musical works may be made without permission. However, this is often limited to specific situations where the recording does not affect the market or commercial interests of the copyright holder. Example: a recording of a poem for educational purposes, where the recorded material is not distributed for profit, may be allowed under this exemption. 7. Other exceptions under Section 52. Additional exemptions. There are several other exceptions under Section 52 that address specific needs. Use by libraries or archives. Libraries, museums, and archives can make copies of works for preservation or for research by users, especially if the work is rare or unavailable. Use in education. Certain uses for educational purposes, like using excerpts from copyrighted works in classroom settings, may be exempted. Parody and satire. Under fair use, parody or satire of copyrighted works may be allowed as long as it is transformative and does not harm the original work's value. Incidental use. Sometimes the use of copyrighted works can be incidental, such as background music or artwork in a scene, without the need for explicit permission. These exemptions are not unlimited, and the use must be fair, which means it should not compete with or negatively impact the market for the original work. Factors such as the nature of the work, the amount used, and the purpose of the use are important in determining whether an exception applies. If the use exceeds the limits of fair use or fair dealing, the person or entity making the use could still be liable for copyright infringement. Whether foreign work is protected under copyright laws? Yes, foreign works are protected under Indian copyright law, provided the country of origin of the work is a member of the World Intellectual Property Organization, WIPO, and the work meets certain criteria. The protection is granted under India's Copyright Act 1957 and is governed by international treaties and conventions, such as the Berne Convention for the Protection of Literary and Artistic Works. 1. Protection for foreign works under Indian law. India provides copyright protection to foreign works based on the principle of reciprocity. This means that India recognizes and offers protection to the works originating from countries that offer the same protection to Indian works. Reciprocity with WIPO member countries. According to the International Copyright Order, works originating in countries that are members of the World Intellectual Property Organization, WIPO, are granted copyright protection in India. This is in line with the Berne Convention, to which India is a signatory. Countries under International Copyright Order. WIPO comprises many member countries, and India has entered into international agreements ensuring that copyrighted works from these nations are also protected within its borders. Therefore, the copyrighted works from these countries will be granted protection, even if the author or creator is not based in India. 2. The Berne Convention for the Protection of Literary and Artistic Works. India has been a signatory to the Berne Convention since 1928, and this international treaty mandates that works created in one member country must be protected by all other member countries, regardless of whether the work was created or published in that country. The Berne Convention is a global framework for copyright protection and ensures that foreign works benefit from protection when used in India, as long as the country of origin is part of the treaty. Example: a novel written by an author in the United States will be protected in India even if the author has not registered the work in India. Similarly, a film made in Japan will also be protected under Indian law if Japan is a member of the Berne Convention. 3. What does this mean for foreign works? The copyright protection for foreign works granted by India has the same rights and benefits as those offered to works created within the country. These include the right to reproduce the work, the right to distribute copies of the work, the right to perform, display, or adapt the work, the right to prevent unauthorized use of the work within India. Essentially, the protection ensures that the creator or copyright holder of the foreign work can seek legal recourse in Indian courts if their rights are violated, just as Indian creators can seek protection for their works abroad. 4. Works not covered. It is important to note that not all countries are part of WIPO or the Berne Convention. If a country is not a member, the works created in that country may not enjoy automatic protection in India. However, India may enter into bilateral agreements with specific countries to grant copyright protection, even if they are not a part of WIPO. 5. Duration of protection for foreign works. The duration of copyright protection for foreign works is generally the same as for Indian works, depending on the type of work. For example, literary, dramatic, musical, and artistic works are protected for the lifetime of the author, plus 60 years. Cinematographic films and sound recordings are protected for 60 years from the date of publication. However, if the protection in the foreign country differs from India's, the shorter duration may apply when the work is being used in India. Question 8. Whether copyright protects ideas. ANS. While copyright does not protect ideas, it provides a safeguard for the creative expression of those ideas, ensuring that the author or creator retains control over their unique version of the work. For example, even though two people can have the same idea for a novel about a detective, they will each have the right to copyright their individual expressions, their own unique writing, character development, and plot. However, neither author can prevent someone else from writing a novel based on the same broad idea of a detective solving a crime. For more detailed information, visit the official website of VMK Professionals, www.vmkpros.com, and always review the latest amendments before execution, as laws keep changing frequently. Does copyright apply to titles and names? Copyright does not ordinarily protect titles, names, short word combinations, slogans, short phrases, methods, plots, or factual information. These elements are generally excluded from copyright protection for a few key reasons. Let's break it down. 1. Copyright protects creative expression, not functional or descriptive elements. Copyright law is designed to protect the creative expression of original works. However, titles, names, short phrases, and other similar elements are typically seen as either descriptive, functional, or too short to be considered original works of authorship that warrant protection under copyright law. Descriptive or generic nature. Titles and names are often descriptive or functional and do not show enough creativity to be protected. Too short to be original. Copyright law requires a certain level of creativity and originality. Titles or short phrases typically don't meet the minimum threshold for originality that copyright law requires. 2. Titles and names are generally too simple to be considered original works. The reason titles and names aren't protected is that they are typically considered too simple or generic to be eligible for copyright protection. Copyright is designed to protect longer, more complex expressions, such as the full content of a book, film, song, or artwork, where originality can be clearly demonstrated. Example: The Great Adventure. This title is a very generic and descriptive phrase. Copyright would not protect it because it is too common and doesn't contain sufficient originality. 3. Short phrases, slogans, and methods are excluded. Similarly, short phrases and slogans also don't meet the threshold for copyright protection, since they are typically brief and functional. The law sees them as too concise to protect as original creative works. Slogans and short phrases are commonly used in marketing and often serve a functional role, like advertising, rather than as artistic expressions. Example: Nike's "Just Do It." While this slogan is iconic, copyright law doesn't protect short phrases like this. However, it may be protected as a trademark. 4. Methods, concepts, and factual information aren't protected. Copyright also doesn't extend to methods, concepts, or factual information. These are typically seen as functional or public domain material, which the copyright system doesn't cover. Methods and concepts. These are often used in industries like technology, business, or science. Copyright is meant to protect creative expressions, not functional tools or processes. Factual information. Copyright cannot protect facts, data, or other information that is not creative. For example, a recipe or a list of historical events is not protected by copyright because these are facts or ideas, not original expressions. Example: a list of ingredients for a recipe. The list itself is factual information and is not protected by copyright. However, a written recipe with unique language or creative expression may be eligible for copyright. 5. When can titles, names, or slogans be protected? Although titles, names, and slogans aren't eligible for copyright protection, they may be protected under other areas of intellectual property law, like trademark law. Trademark protection. Titles, names, and slogans can be registered as trademarks if they serve as distinctive source identifiers for goods or services. If a title, name, or slogan is used to distinguish a brand or business, it can be protected under trademark law, provided it meets the criteria for distinctiveness and usage in commerce. Example: Harry Potter is both copyrighted as a literary work and also protected as a trademark for merchandise, movies, and other products. Similarly, Coca-Cola is a trademark for the soft drink and its associated brand. 6. Copyright protects what is fixed and original. Copyright protection is given to original works of authorship that are fixed in a tangible medium of expression, such as a book, song, film, artwork, or computer code. Titles, names, short phrases, and slogans are often too short or descriptive to meet the originality requirement, and therefore they do not qualify for copyright protection. If you want to register a copyright for your work, contact VMK professionals today. We'll help you protect your creativity with a smooth and hassle-free process. Visit www.vmkpros.com or call us now to get started. That's it for today's video. We hope you learned something new about how copyrighted content can legally be used without permission. Don't forget to like, share, and subscribe to our channel for more legal and creative insights like this. See you in the next video.